Good afternoon, everyone, and to those joining us from the United States and other regions, good morning. It's my pleasure to welcome you to the webinar this afternoon that has been organized by EUBU's Compliance and Investigations team. I'm delighted to be joined this afternoon by a distinguished panel of speakers across various jurisdictions. We're not sitting in a room, so I won't be able to say to the left of me or to the right of me, but with me this afternoon, I have Errol Mehta, who's a partner at Mayer Brown, as well as Harun Rao, who's also a partner at Mayer Brown LLP. Both of them are U.S. attorneys. I also have the pleasure of Christopher Graben joining us this afternoon. Chris is a UK attorney. And last but not least, I have Chiazo Okadibo, who's an associate director with Deloitte, based in Nigeria, but our work covers West Africa. We're delighted to be joined by these distinguished panel of experts in compliance and investigations. And it's my work, it is my opportunity, it is my pleasure, I beg your pardon, to welcome all of you to today's webinar, where we will be discussing the United States recent executive order on the Foreign Corrupt Practices Act and the implications for global compliance. By way of an introduction, on February 10, 2025, President Donald Trump signed an executive order which introduced a 180-day pause on the enforcement of the Foreign Corrupt Practices Act, which I consider to be a very popular legislation for many of us that are compliance and investigations professionals, and many advisors to institutions that have to comply with this law, whether in the US or outside of the US. The pause that was introduced in the executive order essentially, to my understanding, means that the Attorney General has been given some time to review existing enforcement actions and to develop guidelines that align with American economic priorities and national security interests. Because of the role that the United States plays in global compliance, and essentially the role that the FCPA plays in ensuring that American businesses continue to do business properly abroad, we thought it was essential to have this conversation to discuss the impact of this executive order and what it means for global compliance. There's been a lot of debate regarding whether the executive order even has the force of law, and whether all of the institutions that were either required to enforce the provisions of the FCPA are all, sort of on pause in relation to prosecuting violations under that law. And some of those conversations will be the focus of today's webinar. I would like to start this conversation with the US attorneys, because I think that they will bring a lot of insight into our conversation and into what this executive order actually means. So without further ado, I would start with Errol, if that's okay. And Errol, you can start by introducing yourself in a few words. But essentially, I'd like you to set the tone for our conversation today by providing an overview of the executive order and clarifying whether it carries the force of law in view of the ongoing debates that I mentioned a few seconds ago. And I'd like you to comment on whether, even if it doesn't carry the force of law, in the traditional legislative sense, what are the implications of the executive order? What role does the Department of Justice and the SEC have to continue to play in spite of the terms of the executive order?
Thank you so much. Appreciate you having me on here, and good day, everybody. As mentioned, I'm a partner here at Mayor Brown in New York. And prior to that, I was at the Department of Justice for a little over 10 years, most recently as the chief of our Business Securities Fraud section at the U.S. Attorney's Office here in New York City. In that capacity, I did a number of FCPA cases, including most recently the case against Raytheon and Gunvor. It was just last year. So to answer your question about the executive order, generally, um, the order doesn't mean that there is no more FCPA. The FCPA is a law, it's on the books, it applies. What the order means is that the President Trump has decided in his discretion to tell the Department of Justice to no longer, you know, enforce the FCPA as is for 180 days. So 6-month review process, pause, so to speak, on FCPA enforcement. That means that, for example, I was just at the department recently. I left just a few weeks ago, and so we were directed to no longer issue subpoenas or do any search warrants. So essentially, even on existing cases that we had already opened, investigations, we are not permitted to take any action to move the case forward, interview witnesses and so forth. That's sort of what the practical implication of the EO is. It also means that there will be no new cases initiated during the 6 months. Most recently, there's a trial in New Jersey involving executives of a company called Cognizant, a multinational company with operations in the US, based out of India. And in that case, that's a case that's pending for many, many years. I think it opened back in 2019, the indictment. And so it's been a long delayed trial. The trial was supposed to start a couple days ago. And there, the U.S. attorney, it's the chief officer in New Jersey, citing the executive order, has asked the court to adjourn the trial for 6 months. So that's an example of the effect of the EO in real time. You have a trial that's been pending for a long time, and the U.S. government has asked the judge to push the trial for 6 months during this sort of pause in enforcement. So I'll stop there, but that's sort of a general, sort of overview of the order and what it means for the Department of Justice.
Thank you. I think I'd like Aaron to share some comments along those lines as well, given that both of you are the U.S. attorneys we have on this panel. Specifically, I'd like Aaron to comment on the immediate implications of the executive order as well, and how it will impact on investigations involving FCPA violations, both now and in the future. Errol has already given some examples of ongoing cases, and I'd like you to share some that you're aware of as well, to the extent that you can. Are there cases that are ongoing despite the executive order?
So first, thank you so much for having me on this webinar today. Along with Hyrule, I'm a partner in Mayor Brown. I am based in the Washington, D.C. office. Until late last year, I was the Deputy Assistant Attorney General overseeing the Consumer Protection Branch of the Department of Justice. Held that position for about 3.5 years. And before that time, I was a prosecutor for a decade. Also was the president of an investigations firm and spent some time in the White House counsel's office in the Obama administration. Delighted to be here. Hyrule has provided a great overview of what the EO does. As he noted, it's requiring the Attorney General to review all the guidelines and policies governing investigations and enforcement actions under the FCPA. There's a review period for 6 months. And as Hyrule noted, that means no initiation of new FCPA investigations or enforcement actions. There is a provision for an exception The Attorney General can determine if exceptions need to be made, but I'm not aware, at least at this stage, that any exceptions have been made. This is supposed to be a detailed review, and they're looking, according to the EO, to determine whether the proper bounds of the FCPA, in this administration's view, are being adhered to, specifically with respect to presidential prerogatives related to foreign policy. There's an expectation in terms of what's coming that we may get some updated guidelines and policies. And the Attorney General also has the option to extend this review again for another 180 days. So in terms of the immediate implications, what we're looking at is this review process. As Hyrule noted, there is no change in the law. And so even under the broadest projection of a deprioritization of FCPA enforcement, we have to remember that there is going to be a presidential election in 4 years. White collar enforcement has long been a stated priority for both Democrats and Republicans across administrations for many years. And I think it's important for everyone on this webinar to recognize that there could very well be a swing in the opposite direction in the next administration. The statute of limitations for FCPA cases is 5 years. That can be paused additionally as DOJ seeks foreign located evidence. There are a number of ways in which the statute of limitations can be told. And so one of the important questions, Adiola, that has not yet been addressed is whether DOJ can continue to pursue tolling during this enforcement review period. There are many actions that Hyrule noted that the department is not taking now. Their ability to toll is going to be one of those questions that we'll have to look at to see whether there'll be enforcement down the road. As to the second part of your question regarding what happens to already indicted cases, this is unilateral authority that the department has to pause FCPA investigations that are not yet charged. Cases that are in courts, as Hyrule noted, are in a different posture. And he pointed to the example of the upcoming trial in New Jersey related to these 2 former executives at Cognizant. The U.S. attorney has asked for to put the trial on hold while this 180-day pause is in effect, but that's not up to the executive branch. It's not up to the U.S. attorney. The judge is ultimately going to be the one who makes that decision, and he's independent of the administration and independent of the president's direction here. He has asked the prosecutors for more information on how that delay is going to affect the speedy trial rights that the defendants do have. And so we're waiting to see how that plays out. There's another example that I'm aware of involving a vice president at a coal company who's scheduled to stand trial starting in April 21st in the Western District of Pennsylvania on charges of conspiring to bribe Egyptian officials. And on Tuesday of this week, the acting U.S. attorney for Pennsylvania asked the judge in that case to delay the start of the trial to May 5th to give some time to assess. And so it's still early. We're going to have to see how these things play out. And I'll stop there.
Thank you so much for that perspective. I particularly find insightful what you said about election cycle and how that interplays with the statute of limitations for enforcement cases under the FCPA. So this takes me to Chiazo. Chiazo, first I'd like you to introduce yourself briefly and talk about what you do at Deloitte. And then I'd like you to provide some commentary on the Nigerian anti-corruption framework, and also on the impact, if any, that the enforcement pause could have on local subsidiaries of US businesses that are operating in Nigeria. And to provide some context into why I think that, your insight would be helpful to us this afternoon. There is a saying that when the US sneezes, the whole world catches a cold. So essentially, why is this enforcement pause important for local businesses or local subsidiaries of US businesses in Nigeria?
Thank you very much, Adela, for that interesting question. I'm an associate director with Deloitte. I do forensic support for various clients across West Africa. Particularly, I've advised a number of clients on how to, build their anti-corruption and anti-bribery frameworks, have conducted investigations around, those topics as well as, building robust AML frameworks as well. So to your question, Nigerian's anti-corruption framework is found in various legislation and, acts. To mention a few, we have obviously the Constitution, there's the EFCC Act, there's the ICPC, what we call the ICPC Act locally. There are even bits of it in the Company and Allied Matters Act, as well as obviously the Criminal Code, right? And what we see in a number of these legislations is that there has been alignment with various global conventions and agreements, whether the FATF recommendations or the UNCAC, convention. So you can see, the attempt by these various legislation to align with some of these global, conventions, right? Now, when it comes to it, it is interesting, and I think a lot of people find it quite interesting to learn that Nigerian anti-corruption legislation is actually more stringent than even the FCPA. So, for example, facilitation payments are not permitted. And reading through the criminal code, public officers can actually be indicted for attempting to receive bribes. So it doesn't need to have happened. The fact that you agreed to receive it or you attempted to receive it, whether directly or by proxy, is, sufficient to fetch at least 7 years in prison, right? So it's actually more stringent than a lot of the laws that we see. But what we find from our perspective is the issue or the problem has always been around enforcement. So if I go to the second part of your question, what effect could this pause, have on local subsidiaries of US businesses operating in Nigeria? So from a compliance requirement standpoint, as far as I'm concerned, nothing has changed, right? Because one, the FCPA still does apply. Those compliance requirements have not gone away. And of course, our local laws still remain the same, right? So for every US company that is operating locally, beyond the FCPA, they also need to comply with our local laws. But what I see is there might be an impact from a compliance motivation standpoint. And what I mean by that is knowing that in the past years, the FCPA enforcement has been a huge deterrent, for companies and a huge motivation for them to comply. Learning of this force might now mean that there will be a tendency for companies to become lax about compliance, knowing that in any case, even if something happens, we might not get the stick for it. So that's what I see, the risk that I see, even though that is a very costly viewpoint to hold, because like a lot of, all the other persons have said on the call, this is really just a pause and not a stop. And the expectation at the end of the exercise is that there will be more clarity on how enforcement will be handled going forward. So it's not even saying that enforcement will stop, but it's just saying that there will be a lot more clarity as to how, enforcement will go on afterwards. So I think I'll take a pause here and hand it back to you, Adiola.
Thank you, Chiazo. In your remarks, you did say that, violations of the Nigerian anti-corruption framework could lead to up to 7 years imprisonment. And this makes me remember times when we have to, conduct trainings for clients, particularly US businesses that are doing, US corporations that are doing business in Nigeria, their local subsidiaries, or even as contractors. And, when we outline the penalties, including fines and imprisonment terms under Nigerian anti-corruption laws, one of the things that I hear, them, all scream in the room is, I don't want to go to jail. I don't want to go to jail. And I think that's still old sway in view of the comments that you've provided regarding nothing having changed despite the executive order. So thank you for that. I'll turn to Christopher now. Chris, I'd like you to briefly introduce yourself and what you...
I think you muted yourself, sorry. Yeah.
Thank you. Yes, so I was saying that I'd like you to introduce yourself. And after that, you're the only UK lawyer on this panel. I'd like you to provide some commentary on the UK Bribery Act's extraterritorial effect and whether, despite the executive order, US businesses will still face challenges for violations. Also, I'd like you to comment on the main points of contrast between the UK Bribery Act and the FCPA, and whether you think that the pause on enforcement actions under the FCPA would make cases that are being prosecuted under the UK Bribery Act to be challenged in view of the executive order.
Sure, yes. Thank you, and thanks so much for having me. My name is Christopher Gribbin, and I am a managing associate at a firm called Mishcon de Reya in London. And I'm a white-collar crime and investigations and compliance lawyer, and have acted in various serious fraud investigations and prosecutions over the last decade. And it's the Serious Fraud Office in the UK which is most frequently charged with dealing with these sort of cross-border corruption cases. The legislation that they use is the Bribery Act, which is a significantly more recent piece of legislation than the FCPA. It's only 15 years old. It's the Bribery Act 2010. And it has, as a piece of legislation, I think a very good reputation. It is, as we were hearing, much like the Nigerian anti-corruption legislation, it is actually wider than the FCPA insofar as it bites against payments to private individuals as well as public officials, and it prohibits facilitation payments. So it's wider in that sense, and it operates against individuals and corporates. And to take the issue of corporate liability, which is the one that is perhaps of most interest, what's most interesting about the Bribery Act is that corporate liability is established by effectively an omission on behalf of the company. It's a failure to prevent bribery. And there is a defense that the company had in place reasonable procedures to mitigate that risk such that they shouldn't be held liable. But the liability is effectively strict. If the offence takes place, you are held liable as a corporate for failing to prevent it from taking place. And in terms of extraterritoriality, which is the last bit of scene setting, for corporates, the UK Bribery Act establishes jurisdiction anywhere in the world, provided that there is a UK nexus, which in terms of corporate liability is that there is either a UK company, so a company headquartered in the UK, or a company based anywhere in the world, but is carrying on business or part of its business in the UK. So to go to your question, Adiola, where does that leave US companies? Well, it means in legal terms that they are still very much exposed to liability if they have that sufficient UK nexus. So as a US company, they're obviously not going to be a UK company by definition, but they may well be carrying on business in the UK sufficient to meet the test for the purposes of liability under the Bribery Act. So although that's clear in legal terms, this is obviously new territory, and it is very difficult to predict how it is likely to work in practical terms. Because historically, if we had a large cross-border anti-corruption investigation and there was a US company caught up in it, then the expectation would be that the DOJ would likely take that part of the case pursuant to the FCPA and enforce that aspect of it there as part of a cross-border settlement. So a US company now, I mean, and by which I mean now in the next 6 months, who knows what's going to come afterwards, as I know we've already talked about. An interesting question is what will happen to that US company now? Will the UK have the appetite to go after that US company? Will the US assist with MLA requests? Will they even be able to assist with mutual legal assistance requests? Is a very interesting question. To the second part of your question about whether or not there's prospect of similar action in the UK as we've seen with the executive order in the US, I think not. In fact, I would be extremely surprised if that was the case. There is no prospect of Bribery Act enforcement being paused in that way. And in fact, the direction of travel in the UK over the last over the last 15 years, but in particular the last few years, has been to actually increase the level of financial crime compliance-based offences, such as the Bribery Act. There's a new offence coming into force in September, which will create make it an offence for companies to fail to prevent fraud, and that'll have an extraterritorial liability. So the direction of travel in the UK is actually in favour of greater enforcement, but that is not to in any way sort of diminish the complexities that this executive order now presents whenever there is a US aspect in respect of any investigation, and how that will play out is going to be fascinating and is an unknown. So I'll leave it there for now.
Yeah, what I have a follow-on question for you, Chris. So within this 180-day pause period, what do you think the UK regulators will do? What's your sense from an enforcement perspective?
So if there's no US angle, it would be immaterial. If there's a US angle, I would expect them simply to wait it out for these first 180 days. These are cases that sort of infamously move slowly. They take a long time to investigate, and I would expect things simply to be put on ice. That's simply my supposition. I don't know, but I would be very surprised if any firm decisions were taken. Obviously, once we get past that 180 days, once we've got a little bit more, we're a little bit clearer sighted on what's coming, then decisions might have to be taken about how things proceed on an investigative basis. Those cases that are at trial, and I have to say it's very unusual for corporate to take this matter, a Bribery Act matter, to trial. They almost always have some sort of deferred prosecution agreement. But individuals, it is more common. They won't be affected. They will carry on. By the point that the case being at trial, the investigative work is done, the case should be ready to go and be completely unaffected by this development.
Okay, thank you. I'm coming back to you now, Hiral. So we've spoken about, enforcement actions in the context of investigations and generally anti-bribery offenses. I'd like to take the conversation now to other areas. So, for example, my understanding is that the FCPA has, two broad objectives in terms of, anti-bribery and corruption, but also bookkeeping for US businesses and reporting, etc. So I'd like you to provide some thoughts on the impact of the executive order to the applicability on US anti-money laundering laws or other laws outside of, the general anti-bribery and corruption framework. And I'd also like you to share your views on what, where companies need to do to ensure that they comply with local regulations in the countries where they operate, in view of the anti-money laundering laws that you will be talking about.
Yes, definitely. So the FCPA, as you mentioned, has two sort of main provisions. There's the anti-bribery provision, and then there's essentially a books and records inter-accounting control provision, which the SEC also enforces civilly. Historically, the FCPA has not prosecuted companies on the books and records or county control provision if there isn't also evidence of bribery. So typically standalone books and records cases are rarely brought. And I would suspect even if the FCPA does go forward after the pause, that this administration would not be bringing cases just on books and records from a criminal standpoint. Does not mean the SC would not do that civilly, but criminally, I don't think that that would be. I sincerely doubt that that would be a thrust of this administration's agenda. Now, I would say that you're right. Just because the FCPA is on pause right now does not mean that the US government does not have other laws to get at similar conduct. So historically, the FCPA does not, for example, apply to everybody. So it only applies to US persons or issuers. And so if there are some certain times when, for example, individuals that are not covered by the FCPA but are engaged in bribery abroad, in foreign bribery, the US has brought money laundering charges against them. So, for example, recently when I was at the government, I did a trial against the former finance minister of Mozambique, and he was charged with money laundering because under US law, money laundering it includes any transactions that are the proceeds of bribery, of foreign law. So what that means is, for example, if you violate Nigerian law, Nigerian bribery law, and the money from that violation is transacted through the US banking system, which includes correspondent banks, that's money laundering. So what that means for everyone out there is that even though the FCPA is on pause, it does not mean that the US government still could not prosecute and enforce from an extraterritorial standpoint the violation of foreign bribery through the money laundering statute if any transactions hit the US. And as you know, almost all US dollar transactions have to clear through US correspondent banks. And so, for example, if a company, a multinational company in Nigeria paid a bribe to someone, let's say in the Middle East, in dollars, likely that transaction could clear through the US banking system and therefore could be under the aegis of money laundering in the US. I will also just note that Arun's right that statute of limitations for bribery under the FCPA is 5 years, and for books and records, it's 6 years. And there's I think Chris mentioned the MLA process, which is the mutual legal assistance process that countries have. There are treaties, as I'm sure all of you know, between countries to help get documents and information. And so the US law also permits the tolling of the limitations period for FCPA or any law up to 8 years through the MLA process. So what I would tell and caution any companies out there is bribery is still illegal. Almost every country in the world has an anti-bribery provision. And the US government can still enforce US laws extraterritorially through money laundering, for example, and potentially in the future after the pause ends or if the change administration.
Thank you so much, Aurel. I think this takes us neatly into part of the discussion that I'd like us to focus now in terms of the institutions that have an obligation to enforce the provisions of the FCPA. And this is for you, Harun. My understanding, again, is that the US Department of Justice and the Securities and Exchange Commission are the two primary agencies that are responsible for enforcing violations under the FCPA. So I would like you to elaborate on whether the executive order applies to all agencies, and whether the pause applies to all agencies, or whether other agencies will continue with their prosecution of violations under the FCPA despite the pause.
Thank you.
Yes, you're right, Adeola.
Oh, sorry. Is this directed at
for
me?
me.
Sorry.
It was for
I think you
Heron.
mentioned-
Yeah, but I'll let you comment shortly. Yeah.
All right. So, what I was going to say was that, the FCPA is enforced by the Department of Justice criminally and then civilly by the SEC. However, I'm at a conference right now in Miami, and the deputy director of the SEC was on a panel yesterday and made some news. And so I can give you breaking news. She was asked whether or not the SEC would be enforcing the FCPA, and she said we would be following the DOJ. So even though the executive order does not actually mention the SEC, and there's been no mention of what will happen with the SEC and their FCPA enforcement, yesterday the deputy director, Antonia Apps, did say publicly at the conference that I'm currently attending that the SEC currently is going to follow the DOJ. And so that would presumably means there's a pause there as well. And so I think that there won't be any FCPA actions, at least for the next 6 months, either civilly or criminally.
Okay. Thank you. Heron, would you like to comment on that, please, as well?
Sure. Yeah, as has been discussed, the EO is by its terms solely directed to the Attorney General and doesn't give any direction to the SEC. I'm at the same event as Hyrule here in Florida, and he's shared some of the breaking news that we have here on that front. I think it's not surprising that this is what we're hearing from the SEC. For them to proceed would have been at odds with the premise of the EO. And so it's not surprising. One thing to note is that the SEC over the past 10 years has actually brought more FCPA enforcement actions than the DOJ. I think the numbers are somewhere in the neighborhood of about 189 SEC matters and about 154 DOJ matters. The EO referenced facts and statistics that combined the DOJ and the SEC. And so again, not surprising that we are where we are with respect to the SEC. The other thing to note in terms of the decision that we've just heard about from the SEC is that it's not surprising given that the SEC could have had some challenges in pursuing FCPA cases during the pause period without the benefit of a parallel DOJ investigation. Historically, the SEC has benefited from DOJ investigative efforts, support from the FBI, search warrants, things like that. And so, the department opting out of FCPA enforcement was going to have an impact on the SEC. And so not surprising that we are in this situation.
Okay, thank you. I wanted to provide a few remarks to the audience. Thank you, everyone, for joining us. The timing for this webinar is an hour, and therefore, whilst we're continuing with the discussions, if you have any questions at this time, please put it in the chat box, and I will take them in the last 5 to 10 minutes of our time on the webinar. I would like to come to you now, Chiazo, because the past few remarks that have been made relate to enforcement actions and the role that the DOJ and the SEC have played in that regard. From my experience, in past FCPA cases that had Nigerian elements, such as those involving KBR, Halliburton, Siemens, and Technip, the US DOJ are taking the lead in investigations, right? So in view of the executive order, do you anticipate that there will be any shifts in the approach of local or Nigerian regulatory bodies towards anti-corruption enforcement? Because these examples that I've provided, prosecutions of those cases were led by the DOJ. So what are your views on whether we will see in Nigeria any shifts any shifts by our regulatory agencies in view of the executive order?
Okay, so thank you very much for that, Adiola. From my perspective, what I envisage is not so much of a shift, but I think is alternative possibilities. So and I see this from three perspectives, right? One will be our regulators will then need to deepen cooperation with other international regulators. And very recently, I think just about a day or two ago, I read that EFCC, which is, the major crime fighting agency or regulator, had met with the France, one of the directors in their anti-crime agency as well. And basically the discussions were around partnering to train regulators or their officers on asset tracking and cybersecurity. So I envisage that there will be a lot more of that, right, happening. I've also read, in the recent past about partnerships between the Nigerian regulator and the Canadian regulator as well in the sphere of anti-corruption. One other thing that I also see would happen is deepening of local interagency cooperation. So from my perspective, it's almost like we then need to wake up to realize that no one is coming to save us, right? We need to save ourselves. So we need to then start looking inwards. There are certain competencies that we have internally. How can we work, better together? Because there's a lot of information, Adela, if you look at our various agencies and regulators, whether it's SCOMO, whether it's the CAC, there's a lot of information that could be very useful. So I think it would then encourage our local regulators to work better together. And also recently, I was very gladdened to learn that the CAC and the EFCC are talking about deepening collaboration to tackle corruption. And I think this is largely around the beneficial ownership, guidelines that were released not too long ago. Then lastly, which I think might be more long-term or forward-looking, will then be, it would reinforce the need for us to strengthen our enforcement locally, right? It might be the catalyst that we need to then realize that we need to do better when it comes to enforcement. But at the very foundation of this, and which is why I said this is more long-term, is building the right capacity, whether you're talking about the people, the skills, experience, and of course, technology that you need to be able to do this. Yeah.
Thank you very much, Cheza, for that. Whilst we're on the subject of collaboration, I'd like Chris to provide some comments on this, because the DOJ has traditionally led on many high-value and cross-border corruption cases across various jurisdictions, with the SFO in the UK, for example, and other anti-graft agencies assisting. So Chris, in view of the historic relationship between the UK's SFO and the DOJ, what do you think, or what impact do you think the executive order will have on the collaboration between these institutions?
Yes, we've seen this historically, become quite used to seeing it, which is the DOJ working very closely, effectively hand in glove with the SFO or other enforcement agencies, European or local to where the corruption is alleged to have taken place. The biggest examples being Rolls-Royce and Airbus, which I'm sure people on the call will be familiar with, and that way of working has been very successful. And I'm afraid that for so long as this executive order is effective, or at least the substance of it is effective, that way of working must be considered to be in the past, or at the very least on hold. In recent years, although the SFO, domestically speaking in the UK, has actually refocused away from these sort of cross-border cases as a priority, and that's partly because of the director of the SFO is now a former Metropolitan Police officer, and he's brought that sort of more domestic viewpoint to bear on the enforcement priorities of the agency. The SFO still has pursued some cases, most recently opening an investigation with the PNF in France, joint investigation into a defense company. And the last time that happened was Airbus. And interestingly, in that instance, the DOJ ended up joining the PNF and the SFO, and there was a coordinated settlement, which was partly FCPA led by the US, but also something which I'm definitely not the best placed person to speak about it. Something called ITAR, which I understand is a separate offence. I'd be interested to hear views of the panel as to whether or not that might happen this time, if that's where that investigation goes. The short answer is that I'm afraid that old way of working, as we become used to it, it is no longer with us, for now at least.
Yeah, because you said that, you know, the focus of the SFO in recent years has been more on domestic cases. Do you think that the SFO will attempt to fill the enforcement gap left by the DOJ in view of the executive order?
There's been a lot of speculation inevitably about that. And it does present, with an optimistic hat on, an opportunity for the SFO and for others. And to an extent, it really is an opportunity insofar as when there are coordinated settlements, a sort of piece of that enforcement pie, as it were, is given to the US. And that will now be able to be held, to take the example of the joint investigation with PNF and the SFO. If there's no DOJ angle, that's potentially wrongdoing, that provided they can stand it up territorially for jurisdiction purposes, can be retained by the UK and France. So there is an opportunity, and there will be ambitious prosecutors, I'm sure, who will seek to seize that. But there are going to be practical challenges if this EO pertains, insofar as collaboration with the US, and there will always, I'm afraid to say, resourcing difficulties for the SFO who do not have an unlimited budget. It's going to be an area to watch. It's too soon to say, but I'm sure there will be an attempt to plug the gap. But I'd be surprised if it happens. Absolutely.
Okay. The industry is watching, I guess. It's watching what happens next.
Yes.
Okay, I'd like to come back to you now, Hirol, and I would like you. I know you've touched on parts of it previously, but I'd like you to comment more on how you think the policy shift that has been introduced by the EO affects corporations that were previously under scrutiny for FCPA violations, and whether you think that the current enforcement pause would relieve these institutions of their legal obligations or the potential for future enforcement actions.
Sure. I do want to know one thing that Chris mentioned. He mentioned ITAR. ITAR is the International Trafficking Arms Regulation. It's a U.S. law. It's an export control law primarily, but it does dovetail well with the FCPA because it does require companies to disclose any payments made to third parties in connection with various export control functions. And so historically, and we just saw this in the Airbus case and recently in the case that I did when I was in the department in the Raytheon case, where you have an FCPA violation and an ITAR violation. So it remains to be seen whether or not the U.S. will continue to prosecute ITAR violations standalone without the FCPA. And I can tell you that when I was at the department recently, we had a number of ITAR cases that were proceeding, even amidst the pause. So that has not been affected. So that's Chris points earlier. I see your question, Adiola. I think actually it's a really good time for companies to consider voluntary self-disclosure in the next 6 months. It could be a really good opportunity to come in and self-report potentially in a favorable environment. Given the pause and given the priorities of this administration with respect to U.S. competitiveness and whether or not again, whether you agree or disagree, I think that the purpose behind the pause is to foster U.S. competitiveness, without the hindrance of the FCPA. And so this could be an opportunity for companies, if they do have problems internally, if they're aware of issues, compliance issues, to take a hard look, talk to your outside counsel, and consider the risks and benefits of potentially coming and telling the DOJ now about that issue. Because it could be something that you could, get ahead of and maybe get a declination potentially, where you wouldn't necessarily get that like 6 months ago, for sure, and unclear what will happen in the future. As to the general compliance framework for companies, I would, again, caution very strongly, don't bribe people. I don't think that the bribery is not legal. It's still against the law in the United States, against the law in almost every country in the world. And the last thing that I think that you want to do as well, because there's a pause for the next 6 months, that we can now go out and commit crimes. That would be, I think, a very reckless view. I think the right view would be we understand there's a pause, but we have to continue to comply with the laws because there is a lot of uncertainty in this administration and obviously in any new administration that comes forward in a few years. And as Arun pointed out in the beginning of this webinar, the statute of limitations for FCPA is 5 years for bribery and 6 years for books and records. And so that's beyond the scope of the administration, which would be less than it would now be under 4 years. We're already 2 months in. So that's sort of, I think, the general advice would be is, one, take a hard look at whether or not you have an issue and whether you want to maybe voluntarily self-disclose in the next 6 months for favorable treatment by the DOJ. And then two, I think continue to have a robust compliance program, continue to follow the law. Don't let up, because you find yourself in a lot of trouble in the future.
Thank you. Thank you for that, Hiral. So now to you, Harun. Hiral, as mentioned that you've spoken about why companies need to continue to ensure that they remain compliant despite the pause. I would like you to comment on whether you think the executive order would lead to a shift in how corporations conduct internal investigations, because in this is for you, Harun, because in Hiral's past remarks, he did say that one of the things he believes would be beneficial to institutions is to consider self-reporting. So if you look at that in the context of where companies or corporations have an issue, how do you think internal investigations will proceed in all those institutions going forward in view of this recent development? Harun?
Yeah, no, Adiola, thanks for that question. It's a great question, and I think my answer here dovetails with what Hiral said. It would be unfortunate if the pause led to a change, and particularly less scrutiny given, because as we have said repeatedly, bribery is still illegal. Compliance programs still matter. Anti-corruption enforcement is going to continue in some form or another around the country, as this webinar has made clear. And so, it's important to keep in mind when considering how to approach compliance efforts that enforcement of anti-corruption laws throughout the world has increased significantly since the FCPA has first passed, and the current EO is just not going to unring that bell. There are a variety of anti-corruption laws, as our co-panelists have discussed so eloquently, and there's also going to be the possibility of potential civil litigation. And so the other thing to keep in mind in terms of internal investigations and the approach that one might take here is that these anti-corruption compliance benefits that have really become more common over the last few years, they do have a benefit. There is an idea, there is something behind the FCPA that I think matters, that I don't want us to lose sight of. There are benefits in terms of identifying embezzlement, identifying conflicts of interest, identifying internal waste. These are all things that are important to companies, regardless of whether or not the FCPA is being actively enforced by the administration at this time. it also is helpful to companies, right? To know that they are holding themselves internally through their compliance efforts, through their investigative efforts, and allows them to push back against corrupt individuals who are trying to shake them down and demanding bribes. And so I think, the message is the kind of efforts that we've seen over the last decade as this FCPA space has developed, companies would be well advised to continue engaging in those. The other quick point I'd like to make, I know we're coming near the end of our time, is to keep in mind the rhetoric behind this EO. It is very protectionist. It is very seemingly favorable to US companies. And so we should all remember this is a pause. If at the end of that pause, the Trump administration decides that it wants to wield this US law as a tool to provide advantage to US companies, that could have the effect of enhancing aggressive prosecutions against foreign companies around the world. Now, this has some danger for the government. This could lead to selective prosecution challenges in the United States, as was the case during the first Trump administration with something called the China Initiative. But I think it's just something to keep in mind, particularly with respect to the global companies operating in the global space.
Thank you very much, Aaron. Yes, I'm mindful of time, but I'd like to ask Chiazo to provide some remarks or some advice to multinational companies and their officials, many of whom are attending this webinar, on how they can continue to ensure that there is adherence to global compliance standards during the enforcement pause.
So, Adia, a few thoughts from me.
Sure.
We're all as good as our weakest link. So very top of my list will be ensuring that we keep communicating to our stakeholders and employees what the expectations are. They haven't changed, whether the policy or local laws or even the FCPA from a compliance requirement standpoint. So that communication needs to be clear for everyone to know that nothing has changed. Then also, of course, compliance with local laws is very important. You need to comply with whatever laws apply to where you operate, as a business. The other thing it will be important to do is to monitor changes in policy and enforcement guidelines, going forward. And while monitoring that, thinking through how that may or may not impact, your compliance programs going forward.
Thank you. Next question for you, Chris. Do you foresee any long-term implications for global anti-corruption enforcement stemming from the executive order? I'd also like you to share your views on how the pause in enforcement, how it would affect the broader space of international anti-corruption and the behavior of multinational companies.
Sure. I'm obviously mindful of the time as well. I mean, as everyone else has said, the FCPA is still the law, and there are other laws, not least the Bribery Act and many other jurisdictions, which mean that it would be incredibly reckless, I think, for any company, regardless of whether they have a global footprint or not, to disregard the constraints of the FCPA immediately, putting aside the ethical dimension. In terms of what it means, it obviously unlevels the playing field, which, as I understand it, is, as was been touched on, it's sort of partially the objective of the EO. And the reality is that when one thinks about broader anti-corruption efforts, it is bound to have, whether in the margins or otherwise, a negative effect, there'll be exactly how negative is impossible to predict. I just had one final thought, as it were. I was reading commentary about this, and I learned, I wasn't reminded, I didn't know this, that until as recently as 1999, bribery payments were tax deductible in Germany. And so there's not that long ago. And so I think, no one's saying we're going back there, but it shows that anti-corruption efforts are something that we've perhaps come to take for granted, and do need to be protected and do need to be fought for, if they are to endure. And I think that's worth perhaps bearing in mind.
Absolutely. I would like to take one or two questions because I know we have to go in the next few minutes. There's a question here that says, how might the executive order on the FCPA impact entrepreneurs in Africa, particularly those partnering with US companies or operating in sectors prone to corruption? Would anyone like to take that?
I mean, I'm happy to take that. Yeah, I don't know.
Please,
So
thank you.
yeah, so really, the order does not impact entrepreneurs in any way, based on my perspective, because the compliance requirements are still there, right? And knowing that for entrepreneurs who partner with US companies, their principals, who are the US companies in this case, will want to make sure that their partners are doing what they should be doing, so it doesn't open them up to liability. So it's even more, important at this point to ensure that as a partner, you're complying with the FCPA and the local laws, because the US companies should not be letting up on compliance, and neither should you.
Thank you. There's a question here that I believe the US lawyers, is for the US lawyers. It says they're asking whether anti-bribery acts that occurred during the pause period, whether those violations can be prosecuted or paused investigations could be resumed if the DOJ, upon assessment, takes the position that no updated guidelines or policies as directed by the president. Is this potential outcome enough incentive to keep businesses encouraged to remain compliant during the pause period?
Yeah, I think
Harun?
yeah, I'm happy to take this. I think the question's asking that, whether any actions taken during the pause involving criminal violations of bribery, is that right? Would still be prosecuted in the future? I think the answer is
Yes.
absolutely could be yes, absolutely. That I think that is right. That there's no just to be very clear, the FCPA is still the law. It still applies. There's been no change in the law of the FCPA. The only thing that's happened is that the president has directed the Department of Justice to just review the current investigations and to consider what, if anything, needs to be done about future enforcement of the FCPA by the Department of Justice. So obviously the law still stands, and any actions taken in the 6-month period, could put you in jeopardy in the future. Absolutely.
And Errol, would your comments remain the same regardless of whatever the guidelines that are issued at the end of this period says?
Yes,
Would
I
your
mean, I think
answer still be the same?
yes, absolutely. Because I think as Arun pointed out earlier, even if after the pause, the administration decides, okay, we've decided we are not going to pursue the FCPA other than limited circumstances, some exceptions. But for the most part, we're not going to be enforcing this law for the next 4 years. That does not mean that the next administration will have the same policy. And because the FCPA has a 5 or 6 year statute of limitations, it will go into the next administration. And so therefore I would not at all suggest to anyone that there's going to be some kind of you're off the hook for this law. And again, I think we pointed out also before is that there are other laws that also criminalize the same conduct, both in the US and in other countries, including money laundering. I mentioned ITAR as well. So, and a lot of times, foreign bribery can involve wire fraud. So I think there's a lot of ways to get at the same conduct, even if it's not through the FCPA.
Thank you very much. I think that this is a good place to close because I'm mindful of the time of some of our speakers who said they have a hard stop. I'd like to thank all of you, Chris, Chiazo, Harun, and Errol, for your time. This has been a very interesting conversation. And with the number of delegates, I think you agree with me that, you know, they're quite, they found this to be quite insightful. I want to thank you all again. Some of certainly my own key takeaways for everyone listening would be that anti-bribery and corruption enforcement will continue to remain in place despite in one form or the other, despite the pause. And whilst the President of the United States has directed a review of ongoing cases, it is advised that, you know, local businesses continue to adhere to their compliance standards and to the laws of the jurisdictions in which they operate. Some cases will proceed despite the pause. It may be a good time to consider self-reporting or some sort of self-disclosure. This may be helpful for you as businesses. There are other benefits to the FCPA. So we don't see the objectives of the FCPA going away anytime soon. Thank you also very much for your time. Once again, and thanks to everyone that has joined us. We look forward to having more conversations about this subject. Thank you and good afternoon.